3 Supreme Court decisions, all unanimous, all 9-0, all being widely discussed by viral YouTube channels in a way that may give the impression your gun rights just expanded overnight. But here's what many people are not aware of. 2 of these cases have nothing to do with the Second Amendment, and the third case is 5 years old but keeps getting presented as new every few months. If you've seen videos with titles like Supreme Court just changed gun control or this unanimous ruling changes, everything for gun owners, the situation may not be as described. And I'm going to walk you through it right now with the actual case documents, the actual holdings, and the actual implications. Because accuracy matters more than attention-grabbing headlines. Quick question before we dive in. Are you subscribed yet? Because what I'm about to explain is how misinformation spreads in the gun community and how to avoid being misled by it. We're talking about Supreme Court cases being interpreted, simplified, and sometimes presented in ways that don't fully reflect the original decisions. Hit that subscribe button right now because many people are sharing these headlines without reading the actual opinions. Don't be part of that group. Subscribe. Turn on notifications. Let's go through the facts. All right, let's start with the most commonly misunderstood case. National Rifle Association of America versus Volo. Decided May 30th, 2024. 9-0. Unanimous. But here's the first key point. This is not a Second Amendment case. This is a First Amendment case about free speech and government authority. Let me explain exactly what happened. Because the real story is actually more important than the simplified version being shared online. Maria Vullo was the superintendent of the New York Department of Financial Services under Governor Andrew Cuomo. Her agency regulated banks and insurance companies doing business in New York. After the Parkland school shooting in February 2018, there was significant public pressure on gun rights organizations. The NRA was facing intense public attention, and Maria Vullo was alleged to have used her regulatory position in a way that affected the NRA due to its political views. Here's how it went according to the NRA's lawsuit. In 2017, before Parkland, Vullo's department was investigating NRA-affiliated insurance programs. One program was called Carry Guard. It provided insurance coverage to NRA members. The investigation found some violations of New York insurance law. Carry Guard allegedly provided coverage for intentional criminal acts, which violated state law. And the NRA was promoting insurance without the proper producer license. Those were real issues. The investigation itself was legitimate. But then, Parkland happened. And according to the NRA's allegations, Vullo's approach changed. She allegedly met with senior executives at Lloyd's of London on February 27, 2018. At that meeting, according to the lawsuit, Vullo shared her views on gun control and her interest in using regulatory influence to address firearm-related concerns, including weakening the NRA's position. And here's the key allegation. Vullo allegedly indicated that her department would place less focus on unrelated insurance issues if Lloyd's stopped working with gun groups, especially the NRA. In other words, she allegedly suggested a connection between regulatory scrutiny and business relationships. That raises concerns about coercion. She also sent guidance letters on official letterhead to banks and insurance companies doing business in New York. These letters encouraged them to consider the reputational risks of working with gun-related organizations. The letters suggested that companies take steps to manage these risks and support public safety goals. The message could be interpreted as discouraging associations with certain groups. Within weeks, several insurance companies ended their relationships with the NRA. Lloyd's of London ended its underwriting for NRA programs. Chubb Limited stopped its NRA-affiliated policies. Other companies followed. The NRA's ability to offer insurance to its members was significantly reduced. The NRA sued Maria Vullo personally, claiming she violated their First Amendment rights. They argued that government authority was used in a way that influenced private companies based on political viewpoints. The case went to federal district court in New York. The district court allowed the case to proceed. The court said the allegations, if proven, could suggest indirect pressure on companies to distance themselves from the NRA. But then the case went to the Second Circuit Court of Appeals. The Second Circuit reversed that decision. They said Vullo's actions could be viewed as permissible government communication and enforcement activity. The NRA appealed to the Supreme Court. And on May 30th, 2024, the Supreme Court unanimously reversed the Second Circuit. Justice Sonia Sotomayor wrote the opinion, and all 9 justices agreed. Here's what the court said in essence. Government officials cannot use their authority to pressure private parties in a way that suppresses viewpoints they disagree with. The court relied on a 1963 case called Bantam Books versus Sullivan. In that case, a commission discouraged distribution of certain books by implying legal consequences. The Supreme Court said that violated the First Amendment. The same principle applies here. Government cannot do indirectly what it cannot do directly. The court emphasized that Vullo had significant regulatory power, and if that power was used in a way that influenced companies to act against a group due to its views, that raises constitutional concerns. Now here's what's critical. This case does not change gun laws. The Supreme Court did not rule on carrying firearms. It did not remove any gun regulations. It did not expand Second Amendment protections. What it did is reinforce limits on government authority over speech. This protects the NRA. But it also protects many other organizations. It applies broadly across different viewpoints and causes. And this is where many videos become misleading. They present this as a direct gun rights victory. But in reality, it is a free speech ruling. It is important. But it is not what many headlines suggest. All right, case number 2, Barnes versus Felix. Decided May 15th, 2025. 9-0, unanimous. The opinion was written by Justice Elena Kagan. This is a Fourth Amendment case about police use of force during a traffic stop. It is not related to firearm restrictions. Let me explain what happened. On April 28, 2016, in Harris County, Texas, a constable pulled over a driver named Ashtian Barnes. Barnes had several unpaid toll violations. It was a routine stop for a minor matter. The officer approached the vehicle. He noticed the driver moving inside the car. He believed he detected the odor of an illegal substance. He asked the driver to step out of the vehicle. The driver refused. Instead, the driver restarted the car and attempted to leave. Felix made a split-second decision. He stepped onto the driver's side door sill of the moving vehicle. The car was accelerating. Felix was holding on to the outside of the car. He fired 2 shots through the window. Ashtian Barnes died. Barnes's mother filed a lawsuit under Section 1983. She claimed Felix used excessive force in violation of the Fourth Amendment. The case went to federal court. The Fifth Circuit Court of Appeals applied a rule known as the moment of threat doctrine. Under this approach, courts focus only on the exact moment when the officer perceived a threat. In this case, that moment was when Felix was on the side of a moving car. The Fifth Circuit concluded that his fear could be considered reasonable in that instant, so the use of force was viewed as justified under that narrow time frame. The Supreme Court unanimously rejected that approach. Justice Kagan explained that courts must consider the full sequence of events, not just a brief moment before force is used. Everything matters. How the situation began, what actions were taken by both the officer and the individual, whether alternative actions were available, whether the situation could have been handled differently. All of these factors must be evaluated. The court said focusing only on a brief moment does not fully reflect what happened. Instead, courts must apply a totality of circumstances analysis. If an officer's earlier actions contributed to the situation, those actions are also relevant. This decision changes how courts review use of force cases. It replaces a narrow approach with a broader evaluation. This is significant for legal standards. But here is what it does not do. It does not change gun laws. It does not remove any firearm regulations. It does not expand Second Amendment rights. It is a Fourth Amendment case about legal standards and use of force situations. Some online content presents this case as directly related to gun rights, but that is not accurate. It applies to all use of force scenarios, not only those involving firearms. Now let's move to case number 3, Caniglia versus Strom, decided May 17th, 2021. This case is several years old. However, it is often presented as if it is recent. This is another Fourth Amendment case. It focuses on searches and actions inside the home. Here is what happened. On August 20th, 2015, Edward Caniglia and his wife had an argument at their home in Cranston, Rhode Island. During the argument, Caniglia brought a handgun from the bedroom and placed it on the table. He made a statement that concerned his wife. She removed the firearm and its magazine and left the house for the night. The next morning, she could not reach him. She became concerned and contacted the police for a welfare check. Officers arrived at the home. They spoke with Caniglia. They believed he might be at risk. An ambulance was called. Caniglia agreed to go to the hospital for an evaluation. He asked the officers not to take his firearms. The officers agreed. After he left, officers entered the home and removed the firearms without a warrant. When Caniglia returned, he requested their return. The process took time and legal action before they were returned. Caniglia filed a lawsuit arguing his Fourth Amendment rights were violated. Lower courts initially ruled in favor of the police. They relied on a concept called the community caretaking exception. This concept originated from a case involving vehicles. It allowed certain actions without a warrant in non-criminal situations. The lower court applied that reasoning to a home. The Supreme Court unanimously disagreed. Justice Clarence Thomas wrote the opinion. The court said the community caretaking concept applies to vehicles, not homes. Homes have a higher level of constitutional protection. Warrantless entry into a home is generally not allowed without clear justification. Such justifications include consent, a warrant, or a genuine emergency. The court clarified that community caretaking alone is not enough for entering a home. This reinforces existing Fourth Amendment protections. However, it does not eliminate all situations where firearms may be removed legally. It does not address all policies related to firearms. It specifically addresses warrantless entry into homes under that particular reasoning. Some online discussions suggest broader implications, but the actual ruling is narrower. It focuses on a specific legal question and answers only that question. Let's now talk about why these cases are often presented differently online. One reason is that strong emotional reactions tend to increase engagement. When content suggests a major legal shift, people are more likely to click, watch, and share. However, the reality is usually more detailed and specific. NRA versus Volo is a First Amendment case about government authority and free speech. It does not change carry laws. Barnes versus Felix is a Fourth Amendment case about how courts evaluate use of force. It does not remove gun regulations. Caniglia versus Strom is a Fourth Amendment case about protections inside the home. It does not eliminate broader firearm-related policies. These are important decisions. They reinforce constitutional protections. But they are not as broad as some headlines suggest. So how can you identify when information may be incomplete or misleading? First, check the date of the case. If something is described as new, verify when it was actually decided. Second, check which constitutional amendment is involved. Not every case mentioning firearms relates to the Second Amendment. Third, look at the actual holding of the case. What specific question did the court answer? Fourth, consider multiple reliable sources. Comparing explanations helps build a clearer understanding. Fifth, be cautious with absolute language. Phrases like changes everything or completely ends are often oversimplified. Supreme Court decisions usually address specific legal issues. They rarely create sweeping changes on their own. Sixth, look at concurring opinions when available. They often clarify what the decision does and does not cover. Seventh, focus on the actual outcome rather than expectations. Understanding what was decided is more useful than assumptions. Now let's bring everything together. 3 Supreme Court cases, all unanimous, all 9-0. National Rifle Association of America versus Volo, a First Amendment case about limits on government influence over speech, Barnes versus Felix, a Fourth Amendment case about how use of force situations are evaluated, Caniglia versus Strom, a Fourth Amendment case about protections for the home. None of these cases directly change individual gun ownership laws. None of them remove existing regulations. But all of them reinforce important constitutional principles. Understanding the difference between interpretation and actual rulings is essential. Clear information helps people make better decisions. If this explanation was helpful, you can consider following for more content like this. And if you know someone who may benefit from a more detailed breakdown, you can share it. This content is for informational purposes only. It does not constitute legal advice. For specific legal questions, consult a qualified professional. Information reflects understanding as of early 2026 and may evolve over time.